The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, good morning. Please be seated. Welcome to the Fourth Circuit. Our first case, Towers Watson versus National Union Fire Insurance. Mr. Clement, we'll hear from you.
Good morning, Your Honors, and may it please the Court. This case turns on the scope of the so-called bump-up exclusion in an insurance contract. It is common ground here that the losses at issue here come within the insurance contract's basic coverage provisions, which promise indemnification for securities claims arising out of acquisitions and mergers. The question is whether, despite that presumptive coverage, the losses are excluded by the clear and unambiguous language in the bump-up exclusion. Now, that provision excludes judgment and settlements that represent an increase in effective deal compensation. That poses an immediate problem for the insurance company when it comes to the Virginia settlement resolving federal securities claims under Section 14A. It is well settled that you cannot bring a Section 14A claim for increased deal consideration.
I thought Komatsu, among others, said that was somewhat doubtful.
No, with all contrary, Your Honor. I mean, in Komatsu, Judge Easterbrook was absolutely clear that you can't bring I think he was clear that you cannot bring a 14A claim for increased deal consideration or complain that you didn't get a bad price. Now, he said in that case, because of the specific language of the bump-up exclusion, it didn't matter that the 14A claim was going to go nowhere on the merits, because all that mattered in that case was the allegations, because that's what the bump-up exclusion language there
So why is
read
this
on.
case any different?
Because the bump-up exclusion is written differently, and it has two clauses, not one. And the second clause goes beyond the allegations and asks, what does the settlement amount or the judgment amount represent? And in a 14A claim, what the settlement amount or the judgment amount represents is compensatory damages for an inadequate disclosure. And that's just not Seventh Circuit law, that's this circuit's law, that's Supreme Court law. And, you know, if you go back.
Is that stock drop loss? Is that the concept you're getting at?
Well, that's one way of getting at it, but I think the point is even broader than that, which when you're bringing a 14A claim, you can't walk into court and say, I have a 14A claim, and it's premised on the idea that I didn't get enough in this merger. The 14A claim reads on the quality of the disclosures, not the quality of the price that you received in the merger. And importantly, that's different from a state law appraisal claim. And I think in understanding what the bump-up exclusion covers and doesn't cover, it's important to contrast a 14A claim with a state law claim for appraisal. Because in that kind of state law claim, your claim is, I didn't get enough consideration in this deal. And then your remedy in the judgment or settlement is literally an increase in effective deal consideration.
That's a good point, that it's in the appraisal context, it's literally an increase in consideration of the price. But your contract language here says is effectively increased, right? So don't we ask kind of a different question about what is the effect of the award here?
Two things, Your Honor. One is, even in an appraisal action, you get a remedy at the end of it. You don't get an increase in the actual deal consideration. So even in that appraisal action, what you get is an increase in the effective consideration, not the actual consideration. And then the key word that is not actually effective, because that's going to apply in every case, including an appraisal action. The key word is representing. Because my friend's argument basically wants you to read the clause as not saying that you exclude the amounts that represent an increase in effective deal consideration. He wants you to read it as any amount that results in an increase in effective deal consideration. And that position has two clear defects. One is it ignores the plain language of the exclusion, which does not say resulting in, it says represents. And that, I think, calls you to look at what's the essence of what the judgment or the settlement is about, not just the fact that a shareholder gets some additional money out of the settlement on a per-share basis. And that's the second problem with this reading, because there's a general principle that you don't read an exclusion in an insurance contract to render.
But at the end of the day, I mean, what's the difference?
Well, about $70 million, Your Honor, because in a case like this, a 14A case, I think it's helpful too to think about what if this case goes to judgment. If this case goes to judgment, they get a judgment, and that judgment in a 14A claim is for compensatory damages for inadequate disclosure. And so, yes, it's true that for any securities claim.
What would they get there theoretically that they would not get with an appraisal claim?
So they would get something that represents two different things. They would still get, and I understand the point. Like in both
Right.
cases, you might get
If
$2
it's
a
the same
share
amount
for
of
everybody.
money, what difference does it make?
It makes all the difference based on both the language
I
of this.
realize it makes a big difference to your client.
Yeah,
But
but it makes a difference to all the clients out there, because when D&Os, when directors and officers get this coverage, what they are worried about is they're going to get some strike suit from the merger or the acquisition based on, among other things, Section 14A. And they're expecting to get coverage from that. And then if you look at the bump-up exclusion, it excludes a particular kind of claim, which is not a 14A claim. It's a bump-up claim. That's why it's a bump-up exclusion and not a merger exclusion. And that's the fundamental problem with my friend's argument. If you don't read represents to get to the essence of what that compensation represents, you're going to get to every securities claim involving any acquisition and merger is going to mean at the end of the day you settled it and the shareholders in the class get an extra $1 per share.
So it sounded like you were saying just now that you actually disagree with the description of their claim, too. In your brief, you were trying to distinguish between what the claim alleges and then what the settlement represents. But you're saying a 14A claim is just like never a claim alleging that the price was inadequate.
Well, here's the difference, and this is why we focus on the second clause. I would say that a valid 14A claim is never a claim for increased deal consideration.
What if someone settles a invalid 14A claim, right? It wouldn't have succeeded had they gone to trial, but it settled. And then we have to determine, well, what does that settlement represent?
I think you do, and I suppose in some case where the plaintiff never budged off of the position that, yeah, this is a claim that can't go anywhere, but this is a strike suit and you should still pay me something, and then they paid them something. Like maybe in that case, based on that litigation record, you would say it represented something else. Even then, I think I would be saying, look, at the end of the day, I think I could argue, certainly on behalf of the insured, that like nobody pays anything for a completely invalid claim. And so we must have thought that there was at least some way they could have reformulated that to make it a claim for something other than inadequate deal consideration. But if you look at the record here, it is clear that by the time they got to their plaintiff's expert report, they had moved to a sort of reversion theory and a pure compensatory damages theory that actually was premised in their expert's testimony on the merger not going through. So I would say as a general matter, the right way to read these bump-up clauses, at least if they have this form, is if it's a settlement or a judgment for a 14A claim, that's not going to be within the exclusion. If it's a settlement for an appraisal claim under state law, that's going to be within the exclusion.
Why did the stock drop? I mean, what's the reason for which disclosure caused it? Is there any other reason other than this merger, the consideration that arose from the merger?
Well, so their expert says that it was essentially a disclosure problem, and it was a disclosure related to the merger, but specifically it was the failure to disclose that the CEO of Towers Watson, who would become the CEO of the joint entity, had a sort of compensation package pre-worked out when he sort of took over. So that's the disclosure problem. Now, when they come in...
But for the merger, though, there wouldn't be a disclosure problem.
But for the disclosure, there wouldn't be a requirement to have a proxy statement. I mean, so, right, if what we're talking about is but for causation, I mean, I suppose I have a problem. But the language of this bump-up exclusion does not talk about but for causation. It
But
asks,
didn't the shares fall after the consideration, after the disclosure of the merger? It
so,
was the merger that was the basis for the falling of the stock.
right, but Judge Wynn, here's the thing, which is Judge Trenga could not have been clear, and this is at JA 531, that if the plaintiffs walked into his court and said, we're here because there was an adequate disclosure under 14A, and we're just going to get we're going to bring a 14A claim for inadequate consideration in the merger. Judge Trenga said, that's a non-starter. I dismissed your complaint out of hand. JA 531. So what the plaintiffs had to do at that point is to say, all right, I got a 14A claim under Judge Trenga's rule, under this court's case in Lockspire, under the Supreme Court's decision in Santa Fe against Green. I have to bring a claim for a disclosure failure. And then I have to have a theory of compensatory damages that are based on the inadequate disclosure. And their plaintiff's expert could not be clearer that their theory, they were compensatory damages, is calculated on the assumption that the merger would not have gone forward if the disclosures had been adequate.
How did the shareholders learn of that disclosure and the fact that it was going to fall based on that? How did they learn that?
So they learned about the compensation arrangement sort of after the fact. And so that's why some 14A claims are brought in real time. This one was brought sort of after the merger was in fact compensated. But again, their claim wasn't, boy, that price was too low, we're going to have a settlement, that's going to represent the inadequate deal consideration, and we get a bump up. That's a theory you can bring under Delaware law, and there was a Delaware action that was exactly that kind of bump up claim. But that's different, and maybe it's a subtle difference, but I think it's a critical one because it's the difference between this bump up exclusion being a merger exclusion and this bump up exclusion being focused on inadequate deal consideration. And of course, if you go back to why are these bump up exclusions in the contracts, it's a particular moral hazard that the contracting parties are trying to address, which is the buying party is going to give too little in the merger deal. And then they can do that, and then they can settle in Delaware, and then they can effectively bump up the price. And that's what they're worried about. The moral hazard that the seller isn't going to disclose enough is not something that people recognize as a big, broad moral hazard. To the contrary, that's why people get D&O coverage, because they know it's impossible to have a merger and acquisition in this day and age without somebody saying, you should have disclosed a little more, you should have disclosed a little more.
I don't know. Knowingly failure to disclose things you ought to disclose would seem to be a moral failure.
Well, I hope not, which is to say, I don't think Section 14A of the Exchange Act is a moral code. But my point is not whether it's a moral failure. The question is it the moral hazard that these bump-up exclusion clauses are directed at? And they are directed at a very specific concern. And again, if you go back and think about some of the powers you have under Delaware law, if you have 90%, and this is the Santa Fe against Green case, if you have 90%, 95% of a corporation, you can force a merger on the minority shareholders. Their only right, their only way to protect themselves is with an appraisal action. So in that context, there's an obvious incentive to force out the minority at too low a price. And then, of course, they bring their appraisal action, and then when the appraisal action says you got to give them $10 extra a share, you layer that off on the insurance company. I mean, that's what these bump-up exclusion provisions are trying to protect against. But that's very different than the selling company, in the context of putting out its proxy statement, has some inadequate disclosure. That happens all the time, and that is the core of what the D&O coverage is for in the first place. And so I think, and again, I mean, I think once you understand that this clause says representing, not results in, I think we have the best reading, the single best reading of the plain language of the exclusion. But of course, under Virginia law, I don't have to have the best reading. The burden's on my friend to get things within the exclusion, and if there's ambiguity in the language, then it goes in favor of the insured. And I think at best there's ambiguity here, and that's particularly true because, as I've tried to emphasize, if you have this clause to mean what my friend means, it makes the basic coverage for securities claims arising out of a merger and acquisition illusory.
What is your best case for these bump-up exclusions that you seem to say at least limit, I guess, these freeze-outs in a way? What case supports the way in which you've interpreted this?
So the best case that interprets this is the one that we put in our 28J letter, which is the Harmon case from Delaware. And I don't think it's an
Which court is
accident.
that? What court is that?
The Delaware, it's the Delaware State Court, you know, the corporate,
You have a federal case. You have-
yeah, Chancery Court, but of course,
You have a federal court case that supports any of the limitations you've articulated to us very articulately, but I have not seen any research that supports any of the limitations you put forth.
so Santa Fe against Green Industry, Supreme Court case, if you go to that case, Lockspire from this court, all of those cases, and I think this is the point that Judge Easterbrook was making in Komatsu, all of those cases say that you can't have a 14A claim for inadequate deal consideration. So as to the interpretation of the bump-up exclusion clause in particular, then I will point you to that state court case, the Harmon case that we put in the 28J letter. And I don't think it's an accident that the Delaware Chancery Court or the Delaware Court is the one that understands the difference between an appraisal action, which is squarely within the terms of that bump-up exclusion, and a 14A action. They deal with these appraisal actions all the time. They understand that in an appraisal action, the violation is inadequate deal consideration. So when you get a judgment or a settlement of that kind of claim, the settlement or the judgment itself represents the increase in deal consideration. That is not the case in a 14A action. You can't plead it that way, and their expert didn't testify that.
So the basis of your argument arises from the Harmon case, the Delaware Chancery case.
No, the basis of my argument comes from the Supreme
I'm
Court.
speaking specifically to the limitations that you would put on the bump-up exclusion.
I mean, I think the Harmon, I don't think, like, I'm not relying on the Harmon court as authority.
Well,
I'm
that's what you
relying on
gave
it as
me.
an
That's-
example.
That's the one you gave me. I asked you specifically for cases that support the limitations you put on this bump-up exclusions, because I haven't seen any case that has articulated what you've done it very well, but I just haven't seen a case that has limited it in the manner in which you presented today. I've asked, is there a case in the federal courts, circuit, even a district court case, Supreme Court be wonderful, that has put it in the manner you presented to us today?
May I answer, Your Honor?
Please, yes, go right ahead.
The case that I have that does interprets a bump-up exclusion exactly the way that I've tried to articulate it today is just a state court case, Harmon. But
My question, did you hear my question? I said, is there a federal case, Supreme Court, Court of Appeals, or district court case that has articulated this in the manner in which you've done? I'm not talking about the Delaware Chancery Court. Is there a case? It can be yes or no. It's not, I'm not being antagonistic. I'm just trying to help my research because,
Sure.
as I said, you put forth a very compelling case, but I don't know anyone that said it but you on the federal level. So let me hear what you're saying.
So my answer is no, but. And the but is simply that this argument builds on federal cases, including the Supreme Court Santa Fe against Green case and the Lockspire case from this court. And I think this is also consistent with everything that Judge Easterbrook said in Komatsu. And what I'm building on is the idea that there's a fundamental dichotomy between a 14A claim, which is inadequate disclosure, and a state law claim, which is inadequate price. But
You've done that. That's exactly what I saw you doing, is building on it. I just didn't know if anyone else had built with you on this. It sounds like you're building it by yourself, and you want us to join with you in it, and I understand that position.
thank you, Your Honor.
All right, thank you very
Appreciate it.
much. You've got some rebuttal time. Mr. Hacker?
Good morning, Your Honors. May it please the court. The insurance policies provide broad defense and indemnity
Start with
coverage.
the question I just posed to Mr. Clement. Is there a federal case that supports the limitations that he has articulated regarding the bump-up exclusions? Or do you have cases that would point in a different direction from a federal perspective?
So I agree with his answer, no. That's clearly right. As to his side of the equation, Komatsu squarely supports the arguments that we're making, and I'll explain why in a moment. But actually, I can address, because Judge Agee asked the question, doesn't Komatsu reject what I think is his fundamental proposition underlying their entire position here, which is that in a Section 14A case, cannot be about, is never about, in answer to Judge Rushing's question. Mr. Clement said it cannot be about inadequate consideration. And Komatsu, Judge Easterbrook says, that's categorically wrong. That premise, the entire premise of their appeal, is wrong, and he's not the only case, not the only federal and other precedent
So why does he
to have said that.
say that Judge Easterbrook supports his proposition? I mean, you heard it. I mean, it was totally different than what you just said.
I understand.
Where do we draw this line here?
Because I think he is misunderstanding what Komatsu was saying, and more fundamentally misunderstanding what a 14A action is.
As I understood Mr. Clement, he was saying Komatsu stood for the principle that the way that court read a 14A action, it would allow Towers Watson to recover here. That's what I understood him to say. So give us your viewpoint.
Right, and that's incorrect, because what that does, and what Judge Easterbrook was unpacking, was it conflates a Section 14A violation with the kind of loss that you have to establish in a 14A case, and hence the kind of compensation and recovery you can obtain in a 14A case. What Judge Easterbrook is saying, and most courts, not all courts have agreed with this, is that in a 14A action, you cannot, as Mr. Clement says, show up in court and say, the only thing I'm complaining about is that I didn't receive sufficient consideration for my shares. That's not a valid 14A action. That's what they're misunderstanding. That may be true, but what is a valid 14A action is to say that there was a material non-disclosure that caused the shares to be underpriced. And what I'm here in court today, not me, but this hypothetical plaintiff is seeking, is increased consideration because the non-disclosure caused the acquisition to be underpriced. And it is 100% valid compensation to obtain in a 14A action, recovery for the difference between the amount you should have received and the amount you actually received as a result of the non-disclosure. That is a claim alleging inadequate consideration resulting from the non-disclosure, and recovery is absolutely valid. That's exactly what Judge Easterbrook is saying. Indeed, Judge Easterbrook is saying, as Judge Trenga did, that in that kind of case, you actually maybe have to allege that you received inadequate consideration, because that's a necessary element of a 14A claim, is economic loss. This court said so in CARP. The courts all agree that you have to establish, the plaintiff has to establish, the shareholder whose shares were relinquished in the transaction that was underpriced as a result of the alleged non-disclosure has to allege an economic loss. That economic loss, in most and maybe all cases, is going to be the fact that they received inadequate consideration. So that type of 14A claim is a 14A claim alleging that you received inadequate consideration. And it's not just Komatsu. In the plaintiff's class certification motion below, they cited a series of cases that say and hold correctly that that damages in a 14A action can include increased consideration of an amount that compensates for the inadequate consideration that you received. You'll see this at JA 170, but it's a Daimler Chrysler AG Securities litigation. That's the District of Delaware, Judge Wynn. That's a federal case. Sandberg case from this court. Lane versus Page, Brown versus Brewer. Again, they're all collected at JA 170, but they all establish what the plaintiff said to Judge Trenga in that case, which is, quote, at JA 170, it is well settled that damages in a 14A securities action are subject to common methodologies that can be applied class-wide. Here, the applicable measure of damages is out-of-pocket losses, which are the standard measure of damages for Section 14A claims and are, quote, measured by the difference between the fair value of all that the seller received and the fair value of what he would have received had there been no fraudulent conduct or non-disclosure. That's from the Daimler Chrysler case, but that was the plaintiff's argument at class certification. That was the argument that Judge Trenga understood as the basis, and indeed the sole basis, for determining that the damages being sought by the shareholders were predominantly common. What Judge Trenga was saying in the class certification order, the 2020 order, is that I'm going to certify a class here, and really the only disputed issue, as he says at the beginning of his opinion, is whether or not the damages being sought by the shareholder class were predominantly common, and what they were arguing and what he accepted as the basis for class certification was that the plaintiffs were alleging and seeking, quote, that they were alleging, excuse me, that they had received, quote, less than the true fair value from the merger for their shares. That was the stated premise of the plaintiff's motion for class certification. It's what the judge agreed with at the class certification stage. Not that they approved it, but he was saying under Comcast, they don't have to prove that. That's just their theory. It's class-wide. He says at page 9 of the Westlaw opinion, quote, the common question of damages was shareholders, quote, out-of-pocket loss.
This is Judge Tringa speaking here.
This is Judge Trenga
Okay.
in the 2020 class certification order explaining the plaintiff's theory of loss. The only theory of loss they ever asserted from the day one of the case to the date of the settlement, they asserted one theory of economic loss. One.
So help me out. A lot was made in terms of this term alleging and the allegations and the complaint and then the ultimate consideration of whether it should be the litigation conduct, which seems to be kind of where we are now. Explain that in terms of how that affects the 14A analysis here.
So the way the bump up clause is written, it starts with whether or not there's as to claim alleging that the shareholders received inadequate consideration. So that's, why you focus on, that's what triggers the clause, right? You look at the complaint, what's being alleged, and then it goes on to say you have to, as to a claim like that, covered loss does not include, quote, any amount of any judgment or settlement representing the amount by which such consideration, that's the inadequate consideration, is effectively increased. So then you look at the settlement and determine whether any amount of the settlement is an amount representing an amount by which the consideration is effectively increased. And what Towers-Watson is trying to argue is that because part of Dr. Tabak's expert report assumed, and I'll explain this in a moment, but assumed that the merger had been rejected, they're saying it therefore could not have been.
Now, this is
an
the
increased-
plaintiff's expert you're talking about.
This is plaintiff's expert, yes, Dr. Tabak. And I understand Towers-Watson basically have two arguments here. This goes to what it was the plaintiffs and focusing on. They're trying to say the settlement, whatever was alleged, turned out to have been something different. The plaintiffs supposedly shifted gears, and you heard my friend argue that this morning. They shifted gears along the litigation. They absolutely didn't shift gears. The car was in one gear the entire time and pointed in one direction, and that was to obtain recovery for literally the only loss they ever alleged. The only loss they ever asserted everywhere, including in Dr. Tabak's report, was inadequate deal consideration. That's what they said was the problem, and that's what they wanted compensation for. So Dr. Tabak, what Towers-Watson says is, well, Dr. Tabak has two ways of determining the true value of the shares. What both his models were doing was trying to quantify, again, the only economic loss alleged, which was the plaintiffs were saying we should have gotten a fair market value, and we didn't. And that's what we want as a remedy. Again, only thing they ever argued. And Dr. Tabak said, well, there's two ways I'm going to try to figure out what the true fair market value was. And one of those models was to say, I'm going to assume, hypothetically, that the deal was rejected. Only hypothetically. And if I do that, then what had happened in the real world was that when the merger was announced, the share values dropped to the announced share value. They were at something like $135 a share. The deal was announced at, I think, $128. And so, of course, the market price immediately declined to the announced share price. And then there's some market changes over time. The merger eventually gets approved, and the merger closes, and the shareholders holding shares claim that they didn't receive adequate consideration for their shares. And what Dr. Tabak is doing in his first damages model is trying to figure out a way to identify what that delta is, what the true market value is. So he assumes, the plaintiff assumes that the deal doesn't go through, the merger doesn't go through, and the shares bump back up to their true value, their so-called true value, right?
Which in that example, that would have been a $7 difference.
Exactly, and because there's some events in between,
Right.
in the year or so, whatever it was, there's some other things he has to do, some other work he has to do, but that's the premise, right? He's trying to eliminate the merger because of what he calls a merger overhang. That was the drop, that immediate like $8 drop or whatever it was. He's trying to, let's eliminate that by assuming it doesn't go through, and we're gonna figure out the market price. But that is purely a hypothetical. Not once did the plaintiffs ever say, our theory has shifted and we're gonna try to prove that the merger wouldn't have gone through, or that it would have been renegotiated. To the exact contrary, here's what Judge Trenga says in a certification order in response to the defendant's suggestion that, well, you shouldn't certify a class here because this damages theory is basically hopeless. They're never gonna be able to prove that. And what he says, characterizing the plaintiff's response, which he adopts as the premise for his certification order, this is at page 3. Plaintiff contends that under applicable case law, its proof of class-wide damages does not depend on actually proving the assumptions built into Dr. Tamex's damages model. And that assumption is that the deal would have been rejected. They're not trying to prove, not ever did they try to prove that the deal would have been rejected. Continuing with the quote, since economic loss is established by showing that the tower's shareholders received less than the fair value from the merger than was achieved, that was achieved through material misrepresentations or omissions in a proxy solicitation that served as an essential link to the merger. For this reason, loss causation is not determined by reference to whether or not the merger would have been approved, this is the plaintiff's argument, had the alleged non-disclosures been made, but rather by comparing the value of tower stock with and without the merger. So in describing the litigation record, Towers Watson focuses on this TABIC assumption in his first damages measure that the merger wouldn't have been approved, but it's just an assumption. And it's an assumption for the purpose of trying to calculate inadequate consideration. That's literally the sole purpose of that model and what the plaintiffs were trying to obtain in damages. Now, Mr. Clement says, well, they were trying to get compensatory damages, not literally an increase in the consideration they received. But as Judge Rushing pointed out, that's what the bump up clause refers to is an effective increase, which may be true in appraisal action, but it's also true here. It's an effective increase because the only thing they ever argued was that they didn't get enough consideration, they wanted more. That's what the settlement in this situation, given these facts in this litigation record, basically obtained almost by definition. Another way to sort of confirm that is to look at the class members in the case. The class members here were only shareholders who were holders as of the date that the merger closed, who were forced to relinquish their shares for the fixed merger price, right? So the only thing they got was consideration. They sold their shares, they didn't even sell their shares exactly, they were relinquished, and they got consideration. The only thing they could get, even in theory, was more consideration. They weren't trying to unwind the deal, they didn't have shares anymore, they weren't trying to keep their shares and get an extra amount of money on top of that.
And that seems to illustrate that it doesn't, kind of regardless of the theory of the expert or how it's measured, if we're looking at whether it's effectively additional compensation, effectively additional consideration, one of the big questions is, are they still holding the shares or not, right? And if they're not still holding the shares, they were relinquished, they had to be sold, and they're arguing we're owed some money still. It would seem that regardless of how you measure it, there's sort of a presumption that what they're asking for is additional consideration, at least in a context like this.
I think I completely agree with that. I think it's, in this context, it's more than a presumption. That's what they were seeking.
How does that map onto like the Delaware case, where my recollection there was that we didn't have things settled before there were expert reports and theories, shared. Is that right? And then how do we apply this sort of clause in that context? I know they've kind of abandoned that at this point. But
Right, I mean, I agree that they've abandoned. In fact, Mr. Clement today said that was a bump up.
It was a bump up.
Yeah, so I think it's more than abandoned it, they've conceded it. Which, by the way,
But I guess
the case is settled together, but.
Query there is that, here we're getting into all of the nitty-gritty of the experts' theories and how they measured it and what they hypothetically envisioned. But, this clause will also apply in places and in situations where you don't have all that evidence.
I agree with that. I mean, that we're sort of getting the nitty-gritty because they've invited us to go there,
Sure.
and it all, when you actually look, both the nitty and the gritty, everything points to this being an effective increase in deal consideration. But it's absolutely true that in a case like Delaware or many others, where the case settles early on in the case, basically what you have are the allegations, the claim that seeks additional consideration. And if that's sort of all you have, and maybe, this is maybe an important distinction, shareholders, and you're only seeking relief on behalf of shareholders who received consideration, so all they could receive is additional consideration. In those cases, right, I think it probably is, like, at least a presumption that the settlement represents an effective increase in the consideration received. There is Mr. Clement points out the Harmon case, and I think
So
actually.
There's never been an argument here, for instance, that we want our shares back plus X.
No, never. The only thing they ever sought was an amount that reflects the consideration, the delta between the inadequate consideration they received and the true market value. And everything that Dr. Tabak was trying to do was to identify the true market value. He had two different ways of doing it that ended up at the same place, which was, eliminate the merger and the effects of the statement, the misleading statement about the merger that had on the stock price. You eliminate that, figure out what the true market value is, and that's your damages, which is quite explicitly, but at least effectively, an increase in consideration. But there's an important difference. The Harmon case, I think, is illustrative. I'm told some of the factual representations and statements in the opinion are not accurate, so I'm not, at least that's what.
How do
But-
we view the Harmon case? I mean,
Right.
rarely hear arguments that come up here that based upon state court cases at that level. It's not the highest court. And it's an unpublished opinion. I mean, so I get it. It could be saying a lot, but we don't typically even look at our own unpublished opinions too much, or others, but now we're down at a lower state court looking at what somebody thinks is a very important case, but no one published it. And I mean, even there are differences in the cases, I would say, but I'm intrigued by that. That seems to be a focal case here. Is it because this issue just doesn't come to the federal court, or what is it?
I mean, the diversity, it comes to, federal courts and diversity cases, but to the extent, and I'm not asking this court to, rely on Harmon, because it's analytically wrong in a couple of ways we pointed out in our response to the letter. But even accepting, and even if they're not accurate, the factual differences, they're important to understand. First of all, the court there said, and again, I'm not sure this is factually true, but it was important to the court to say that there was no evidence of the true value of the shares. And so it wasn't clear that they were actually sort of seeking the kind of inadequate consideration that was being sought here. Of course, all the evidence, the only evidence was about the true value of the shares. And the court said there, the class, and again, I'm not sure this is factually right, but there it was important to the court that the class included only shareholders who sold prior to the merger closing, right? So they didn't receive, on this hypothesis, this premise, they didn't receive any consideration. They sold prior to the shares. So their claim would be in the nature of like a 10b-5 type claim, if it existed at all. It wouldn't be seeking increased consideration. It would be exactly the kind of stock drop damages theory that Mr. Clement and Towers Watson is talking about, where you're saying, well, the misstatement in the proxy about the merger drove down the price of the shares by $8, whatever it was, and then during the class period, I sold in reliance on, or presumptive reliance on, that statement. And now I want compensation for the stock I sold at an underpriced sub-market price. That's a 10b-5 type argument. That's not the kind of argument that was made here, and only could be made, the only argument that could be made here was by the shareholders who sold or relinquished their shares on the date of the acquisition. And as Judge Easterbrook points out in Komatsu, first of all, the 14A action sort of has to allege that kind of loss. But even to the extent it's not a meritorious claim, I think Judge Rushing asked about this, even to the extent it's not a meritorious claim, he says correctly, that doesn't matter. That was their claim. If you have a terrible claim for receiving inadequate consideration, but that's, and seeking increasing consideration, but that's all you seek, and then the defendant settles it, that payment is an effective increase regardless of the legal merits of your claim. And so I think Komatsu in those two respects is the federal precedent that very much supports our position.
All right, anything else, Mr. Hacker?
No, thank you, Your Honor.
All right, thank you very much. Mr. Clement, you've got some rebuttal time.
Thank you, Your Honor. Just a few points in rebuttal. Let me start with Korematsu. I would urge you to read the entire opinion, but I'm just going to give you two highlights from my perspective. One, and I'm quoting here, whether these complaints stated good federal claims was never put to the test, but the matter is doubtful. Santa Fe Industries against Green, the Supreme Court case, holds that securities laws cannot be used to contend that a corporate transaction did not fetch the best price. Federal regulation is limited to disclosures, while price is subject for appraisal and other remedies under state law. And the other thing I'd like to read, just the last thing of it, because it goes right to what my friend was saying. He finishes the opinion by saying, Komatsu wants us to proceed as if all D&O policies contain the same language, but they don't, so they won't. So we shouldn't. Only Judge Easterbrook could say that. But the point is that these are different clauses, and the clause there turned entirely on the allegations, so Judge Easterbrook could say, these are claims that are going nowhere, but the allegations are all we need to look at. That's not true here. It's common between the parties that you can look beyond that. Just one note on the Harmon decision. We think it's persuasive not because it's authoritative, but because it's a Delaware judge who deals with appraisal actions and knows the difference between a bump-up claim where the settlement or the judgment reflects an increase in deal consideration and other kinds of claims. And for what it's worth, I mean, if you're really worried about its status, it is on appeal to the Delaware Supreme Court. I happen to be counsel there. I like our chances in the Delaware Supreme Court. That opinion would be precedential, so you could wait, I suppose. But I like our chances because the Delaware courts see all of these claims. And they don't just look at this one claim and say, oh, well, you know, at the end of the day, the shareholders there are going to get something more. They understand that there's a range of claims, and disclosure claims, which are federal claims, are different from most state law claims. Just as a matter of clarification, I did not give away the Delaware claims in this case. There are three cases: a Virginia case, the Delaware case, and then a separate Delaware appraisal action. That separate Delaware appraisal action is the one that gave away. The reason we haven't talked about the Delaware case that's involved here is because if we win on the Virginia issue, as I think we should, then that exhausts the policy limits.
Do you want to respond to your friend's point about the 14A claims that you have to have the damage, the loss, that is what we're talking about here, not necessarily the quote that you gave us from the Seventh Circuit's opinion?
So you need a damage theory. Obviously, you need loss causation. It's a federal claim. But then the question is, if you settle it, what does the damages amount represent? Does it represent an increase in deal consideration, or does it represent the damages that you suffered for the inadequate disclosure? And it's clearly the latter. And again, it may result in more money to the shareholders, but it doesn't represent an inadequate deal price. And if you want to get into the details of the expert report, and I don't think you have to, because I just think it's as simple as this: a 14A claim doesn't come within the bump-up exclusion. But if you want to get into the nitty-gritty, there's one thing to focus on that shows what their expert was actually doing. And when he calculates the loss and what came out of the stock on the day after and all of that kind of stuff, before he gives his final number, $6.57 a share, he backs up the breakup fee that would have to be paid by the Towers Watson shareholders, because the whole damages model is based on the idea that this is the compensatory injury you suffered on the theory that the inadequate disclosure, if there had been adequate disclosure, there would have been no merger, no consideration. So because the damages number is based on the theory that the deal doesn't go through, he has to back out the breakup fee. That's how he gets from $7.15 a share to $6.57 a share, and that is irrefutable evidence that the compensatory damages here are not a bump up in deal consideration. They are compensatory damages for inadequate disclosure on the theory that the deal would not have gone through. Thank you, Your Honor.
All right, thank you very much, Mr. Clement. We appreciate the excellent argument by counsel and on both sides. Would that we could have that on a regular basis. And so we'll come down now and greet counsel and then move on to our next case. Ms. Saharsky, we're ready to hear from you whenever you're ready.
Good morning, and may it please the court. The interest netting statute here applies based on its plain text, because interest is running on underpayments and overpayments that are by the same taxpayer. Bank of America is the same taxpayer for the overpayments and underpayments because of the merger. As a result of the merger, it's taken on all of the assets and liabilities and the very identities of the merged companies. That is including for prior events, for any kind of liability, not just tax liability, but for environmental liabilities, tort, contract, anything. Bank of America is now the responsible party for what happened in the past. And to a certain extent, the government agrees with that because they want the merger to make Bank of America responsible for all of those past tax obligations. The merger is what makes Bank of America responsible for the overpayments and underpayments in the first place.
So if we look at Judge Conrad's decision in this case where he discusses the elliptical, I forget the entire phrase, elliptical parentheses, and we were to decide that that was a tad too ephemeral for us to rely on, how does that work into your argument?
So the judge referred to a grammatical ellipse to add words to the statute, right? To add the word made to the statute. I'm not sure that the statute doesn't say made, and it just doesn't fix a particular freeze in time, the consideration of when someone is the same taxpayer. So I'm not really sure if you read in the word made or just say by the same taxpayer that it matters, because the question is, like, when does it have to be the same taxpayer? And made doesn't answer that question. In particular, we know that made, which the judge read in, doesn't answer that question because that language is in the parallel payment netting section, 6402A. It says by the people that made the taxpayer, a person that made the overpayment. And the Supreme Court interpreted that in the Sorensen case to say that's just the person the overpayment's attributable to. It doesn't tell us a time limit. And that's actually the same position that the government had previously taken with respect to that provision. So it just says by the same taxpayer, and the question is, are we the same taxpayer? Right now, we need to do the interest netting. There was a long audit where all of these tax years were opened. In 2014, the government finally came back to us and said, here's the finals, overpayments and underpayments for all these tax years. It's time to do the interest netting. And at that point in time, the mergers had happened, and we are the same taxpayer. So, the government's view, I think, requires you to freeze the statute in time in a way that it's not frozen. And then it requires you to take a second step, which is to say that the merger doesn't have effect for events that happened in the past.
Well, it seemed that, overpayment and underpayment, they're nouns that tell us about an action, right? They're overpayments and underpayments by the same taxpayer are saying the same taxpayer overpaid and underpaid, right? It's telling us who did the action. And I'm struggling with the fact that the Internal Revenue Code sets a date for when the overpayment happened and when the underpayment happened, that those happened in a fixed time in the past, that those, according to the code, they didn't happen when you pay for it. They happened at a fixed time in the past. And why doesn't that suggest that we ask, were these companies the same taxpayer when they made the overpayment and the underpayment?
So the code talks about when interest starts to run on an overpayment and underpayment, so it doesn't say when the payment was made or not made. And in particular, the code defines underpayments as the amount that wasn't paid. So like the missing amount. So you don't make an underpayment, it's like the amount that you still owe. So this idea that they're made on a certain point in the past, I think, is wrong. And if you look at the facts of this case, I think it shows that. It just isn't true that, say, for the test case 1, where we're talking about the 2005 tax years, that you can just say, let's look at what happened in 2005. Let's just freeze it all about what was happening in 2005, and that's when we'll decide. Because the government didn't even decide that there were underpayments and overpayments for those tax years until 2014, after the merger, when both Merrill Lynch and Bank of America filed their tax returns for 2005, so, right at the beginning of 2006, there were zero balances on those tax returns. And the overpayments and underpayments only arose because of the changes that the government made and then made retroactive to earlier dates in 2014. And those earlier dates aren't 2005 dates. There is a 2006 date as the deemed to have occurred date for the underpayment, but the deemed to have occurred date for the overpayment is 2008. So it's just not true that there's like this time that is, we will just look just at the tax year, don't look at anything but the tax year, and just freeze it in time then. If that's true, we don't owe any money. That's the end of it, because there were no overpayments and underpayments then. So the government is doing, I think, the same thing that they try to criticize us for, which is looking at things that happened after the tax years at issue and then making them retroactively applicable to what happened, or to the obligations for those tax years. So it's just, I mean, it's just not right to say that the years are fixed in time, and that's just not what the government is doing. And I don't think that, that is what their guidance represents either. I mean, they, for example, had written guidance on this. It was a field service advisory, so not precedential, but the kind of thing that the U.S. Supreme Court said you could look at as evidence in the Rowan case. They have a field service advisory that says in the context of a merger that you could do interest netting in these circumstances. And the position that they're taking today, I think, is inconsistent with a whole bunch of formal revenue rulings that are binding guidance on them that talk about what it means to be the same taxpayer.
Well, so do I understand your theory correctly, that we have, for your theory to work, we have to look at kind of like the date of payment, or the date that you're settling up with the government, that it's all, the dust is settled and the company decides it's time to pay. That for your theory to work, we can't be looking at the date interest started running for these companies, because they were not the same taxpayer the date that interest started running.
We think that the right way to look at it is the kind of now point in time, the settling up point in time, and I can explain more precisely what that is. But we think that we win even if you look at the past point in time, because the effect of the merger is retroactive. We are responsible
I wondered about that, yeah, because you have a lot of authorities that stand for, I think, the correct proposition that when company A and B merge and become company C, that B is the same as C and A is the same as C. But I haven't seen any authorities that say that makes company A and B the same company. They're both the same as the resulting entity, right? Because they have merged their interests into that resulting entity. But I haven't seen anything saying, well, retroactively, they're like both the same company before the merger.
Well, let me give you a couple of answers. One is based on Delaware law, and in particular the merger statute, which is section 259A. It says that the prior companies become the surviving company, and the surviving company is them as if it always had been that way. So they're all treated as the same. But then second, and maybe more to the point, we have how the government has viewed the same taxpayer requirement before and after a merger in other tax contexts. So they're arguing about it here, right? But they have issued revenue rulings, which are binding IRS guidance. There's 4 of them that we cite in our brief. Section or revenue ruling 59-399, 62-60, 66-125, and 72-356. Let me just illustrate 2 of them because I think they show kind of similar situations. So one is revenue ruling 62-60. The question was, after a merger, is the taxpayer the same taxpayer for purposes of the federal unemployment tax, which depends on, do you have a certain number of employees who've worked a certain number of days? And the merged company had some employees that had worked some number of days, and the question was, do you now attribute those to the surviving company? And the IRS guidance said, yes, for those purposes, they're the same taxpayer. Another example is in Revenue Ruling 66-125, which is about an excise tax refund for like cigarettes. You have to be the same manufacturer for tax purposes, so that if you take cigarettes off the market, you get like a refund of your excise taxes. And there were 2 companies that merged, and one of them had paid the excise taxes. And as a result of the merger, the surviving company said, we want a refund for this thing that happened in the past. And the IRS said, yes, you're the same for those purposes. And so, really for essentially every purpose we can find except for this interest netting purpose, they recognize that we are the same taxpayer. It's true that the merger has to happen, so to some extent you're looking at it going forward. But as you're going forward, there are things in the past, and the question is, are you treating them as the same taxpayer as the surviving entity? And, the service has said yes, and, case law says yes, the Supreme Court said yes in the Metropolitan Edison
all
case.
All of those seem to be talking about the surviving entity, the relationship between the surviving entity and one of the, entities it swallowed, one of the partners to the merger and the surviving entity, not the two entities that existed before, not their relationship to each other. Do you know what I mean? The relationship between A and B, not the relationship to the surviving entity. I mean, 360, is it 368? Yeah, 368 has a term for this, a party to a reorganization, and that includes both the two pre-existing entities and the surviving company. They're all in that definition, but
I think
it seems to be a different relationship.
but they're all considered one and the same. There's the, colorful language in one of the cases about how they all become part of the muscle and bloodstream as if it always was that way. So they all are the same company as a result of the merger, including looking backwards. That's why we're responsible for Merrill Lynch's tax payments from back then in the first place. Like if they weren't us now, we weren't them, and we weren't all of the merged banks, then we wouldn't be responsible for that money. But the government wants the money from us. And so for purposes of getting the payments, it understands that we are all the same now.
That goes to your theory that you're responsible now, right?
Yes.
But we had talked about your theory that looks at now.
Right.
But then this was talking about, could you win if we're looking at, 2008 or whatever?
Right, so let me address both of those. One, I don't think you want to just look at 2005, because if you just look at 2005 and fix it in time, the government loses, because there were no underpayments and overpayments. The only reason that they had those is because they did stuff in 2014 after the merger, and then they deemed it retroactively applicable. So it's not like you just look at what happened in 2005. So I just don't think that they even win under that theory. But in terms of why we're right about the retroactive application, I'll just point you to a few sources. One, Delaware law, which says it is as if we had always been the same company. Two, the IRS revenue rulings that we talked about. Three, rulings from the Supreme Court in the Metropolitan Edison case and the Southgate case from this court. And four, the fact that they recognize that, for things that happened in the past, torts that happened in the past, contract obligations, all of those, like, we are responsible, we are them, going backwards. But to answer the second part of your question, we don't think that you have to decide that question about freezing it in the past, and it wouldn't make sense to freeze it in the past, because no language freezes it in the past in the statute. And we're talking about doing something now. Interest netting only happens at the end of figuring out the overpayments and underpayments, after, say, here in this case, there were a lengthy audit. So at the end of the audit, the government says, okay, here's your overpayments and underpayments, and it's time to do the interest netting. That's what we're trying to do now and get an answer on. That's what this statute talks about. So the statute's time is now. I would just point out one other wrinkle. There's not actually just one overpayment and underpayment, but there are different overpayments and underpayment amounts because the government made different adjustments over time. And so there are points at which there are underpayments and there are points at which there are overpayments. The reply brief, footnote 1, kind of explains this, but the point is that it's not frozen in time. That's what I would say.
Let me ask, taking a slightly different direction, both the district court and the parties discussed this Federal Circuit case, Wells Fargo. And I'd like both counsel to tell me how they addressed this. So in Wells Fargo, there was no netting in what they called Situation 1. That's where the non-surviving corporation had an overpayment before the merger, and the surviving corporation had an underpayment before the merger. So no netting there. And in Situation 3, the non-survivor has an overpayment pre-merger, and the surviving corp has a post-merger underpayment, netting allowed. So as I read through the fairly extensive discussion on Example 3, which went through Metropolitan Edison and all those cases, I came away with the question of, I don't understand why you simply couldn't substitute the facts in Situation 1 into number 3, and there would be netting in both cases. And I don't think that the Federal Circuit's explanation for Situation 1, they say, we have this earlier case, energy something or other, therefore there's no netting. But when I looked at it analytically, going through such test case number 3, I don't see the difference between 3 and 1 from an analytical standpoint, which I suspect you will agree with.
Yes, I think you have it exactly right. I think the Wells Fargo decision is problematic and would not be something you'd want to follow for 2 reasons. One, you identified, which is the internal inconsistency. The court seemed to believe that it was bound by the prior decision in Energy East, which did not address a merger, but addressed a parent-subsidiary situation where there was really never any argument that they were the same because they retained their different corporate identities. And so the court said, I see the red lights on, but can I?
Yep.
Okay. The court said that, Energy East addresses situation one, so we're bound by that, but when we're not bound by that, we're going to have that whole discussion that you mentioned, which basically follows our position. The second thing I would say about Wells Fargo is that it's not consistent with the government's position in this case. The government's position is freeze it in time, right? Freeze it in time. And if you freeze it in time, I don't see how you would say that netting would be okay in situation 3, because there you had two taxpayers with, according to the government, two different names, where one overpayment was before the merger, and then the underpayment with a taxpayer with a different name was after the merger. And so if you took the government's freeze it in time, only look at the past stuff, then they should have said, the Wells Fargo court should have said no to situation 3. And so, we just think there's something deeply wrong with that decision, and so the court should give it a very close look and not follow it here.
Thank you very much. You've got some rebuttal time. Ms. Del Sol, we'll be here, glad to hear from you.
Good morning, Your Honors. May it please the court. This case is exactly like Wells Fargo's situation 1, where the Federal Circuit addressed the same situation where the overpayment and the overpayment happened pre-merger. And we believe that this court should follow the Federal Circuit and reach the same result here. And I'd like to explain why that's
But we're
correct.
not bound by that Energy East case, and that was my point with opposing counsel. When I read through the analysis of test case number 3, it looked like to me that you could put the facts from test case number 1 into that, and you would get netting permitted.
I think that's not correct, Your Honor. First of all, because you are a different circuit, you're not bound by either Energy East or Wells Fargo. But I think Wells Fargo followed Energy East with regard to, you look at the time the overpayments and underpayments happened, because they found that same statutory language applied it required you to look at a particular point in time. And in situation 1, the two corporations, A and B, were entirely separate. Say we're talking the Bank and Merrill or A and
They're separate
B.
in number 3. You have a pre-merger overpayment and a post-merger underpayment.
Well, the situation, that's exactly what Judge Rushing, I think, was getting at when she said beforehand, you have A and B are separate. And at the point in time that you look for this statute, which I'd like to explain why that's correct, is you look at the time the overpayment and the underpayment happened. At that time, they're entirely separate. They've not had any affiliation. And in situation 3 in Wells Fargo, they've combined. They've become A and B, A plus B, or as Judge Rushing suggested, Corporation C. And one is assumed in the other, so that you could say that A is the same as C and B is the same as C. But looking back, there's nothing in either federal tax concepts or Delaware merger law that says that they retroactively become the same. And so I'd like to just get at why you look at that particular point in time and why the bank is wrong that when you settle up is the relevant
time. That just sounds completely wrong to me on Delaware law. I mean, they're pretty clear on the effects of merger, that the surviving corporation takes on all the aspects of both corporations.
Well, I think what's important here, first of all, is we do think this is a federal tax law because you're interpreting a federal statute, and Delaware law simply informs that. But in Delaware law, it speaks in terms of one corporation assuming the liabilities of another, being treated as if they were the same. And I think this is an important difference that my friend repeatedly emphasized, that these Delaware statutes require treating the pre-merger entity as a successor to, as if it were, and regarding them as the same. And I think what's important here is this particular statute requires that they actually be the same. And I think if Congress had wanted to write a statute that says whoever ends up with the liabilities and whoever ends up with the obligation, the rights of the overpayments, if they're the same, netting applies, it could have done that. But it didn't do that. It used these terms, this phrase, overpayments and underpayments by the same taxpayer, which the Federal Circuit said this means you look at when the overpayments and the underpayments happen. And it may be that, when you pay your tax, you pay a certain amount and you don't realize you have an underpayment. but you actually do. What happens later is that audit happens and it's discovered that there actually is an overpayment. But that
Well,
overpayment
under the other
happened
statute,
when
you know,
when it
the-
happened.
The principal tax amount gets netted out. And now you have this interest, so one of the arguments they make, which may not apply for tax law purposes, but just for a common sense approach, it would be difficult to explain, okay, you, the taxpayer, don't owe any tax, but you still owe us interest.
Well, in this particular case, as it's laid out at page 154 through 155 of the joint appendix, what happened was not that the government, the secretary on his own had any authority to net out these tax liabilities. In fact, their position, the secretary's position in this case has been that they didn't have such authority. That instead, what happened is that the bank, in its role as Merrill's successor, not as the same taxpayer as Merrill, asked that Merrill's overpayment be applied to the bank's underpayment, and that commonly happens under Revenue Ruling 6520, which has been going on since the 1960s, that one taxpayer can ask to have its payment applied to the liability of the other. And that's what happened here, as those documents in the record indicate. And I think when you look at Section 6402, which is the offsetting provision for liability, I think it's questionable whether the secretary could have, I mean, I think the secretary reads that as not allowing that authority, because it actually only allows crediting the overpayment against the liability in respect of a tax on the part of the person who paid the overpayment. So that would be, mean that Merrill's the person who paid the overpayment, so it doesn't necessarily follow that 6402 could apply. But even if it does, this is very different language.
But it applied in this case, didn't it?
Well, what I'm saying is it didn't apply. What actually happened, the bank has suggested that, but what actually did happen is that the bank asked another taxpayer's overpayment to be applied to its liability. And that was done because the bank was in the shoes of Merrill after the merger, asking that money
Right.
that belonged to Merrill.
I understand the argument that
Yeah.
you're making there, but it just seems
But
illogical to say that the government, Treasury Department, can say in two identical situations, we're gonna allow the netting of the tax here because we just want to, but over here, same facts, we're not gonna allow the netting.
Well, I think an important part of this is that there is a different statute. There's a statute that specifically deals with interest, and you know.
Right, I understand, but I can't remember the number now, 6402 maybe is the
Yes.
principal tax, the actual tax netting provision, so that's what I'm having an initial difficulty gripping. The government's argument seems to be that we have the discretion, two completely different taxpayer.
I'm not sure that's what we're
Hold
arguing on.
It'll be helpful if you let me tell
Sure.
you what I'm interested in first. So you have two taxpayers, completely separate, but they have the same overpayment, underpayment of tax problem. And you seem to be saying in situation one, we're gonna allow the netting of the tax. And in situation two, we're not gonna allow the netting of the tax because we have that discretion. Is that your argument on the
No,
tax?
No, you're right. I think, well, when you're talking about situation 1 and 2, I'm not sure what exactly you're referring to. Are you talking about the Wells Fargo situations 1 and 2, or are you talking about?
No, that's just my own.
You're just- so-
My own hypothetical.
So-
You've got two taxpayers, have no relationship whatsoever, but both of them were involved in merger situations. They've got tax that's overpaid, tax that's underpaid, and in one situation, the netting of the tax, not talking about interest, the netting of the tax is allowed, but the netting of the tax in the other one is not allowed.
Well, I think whenever one taxpayer asks the IRS to apply its overpayment to another tax's underpayment, that can happen. And that happens between parent and
Can I
subsidiary
just
corporations
clarify
all the time.
what you're saying? Are you saying under 6402?
No, I'm-
That can happen just because somebody asked? Or are you saying, I thought the government's brief said in 6402, we don't think ever applies here, but this is like a gift, and because they're responsible for, you
Well,
know, the Bank of America is responsible for Merrill, and Merrill's responsible for the bank, like we let them choose to pay each other's taxes.
Yeah, I direct your honor to Revenue Ruling 6520, which is the revenue ruling we talk about in our brief that gives the IRS the authority to, when one taxpayer says, I want you to take my money and apply it to somebody else's liability, that the service can do that. And that's what's happened here, as indicated at page 154 and 155 of the joint appendix. And I think in 6402, it actually says that the secretary's authority is limited. It says that the secretary can credit an overpayment, and that's Merrill's that has overpayment here, against any liability in respect of an internal revenue tax on the part of the person who made the overpayment, which would suggest that it could only offset against Merrill's own liability, which is why we don't think that that statute would apply here. But I think even if you could read on the part of the liability more broadly, it doesn't follow that the interest statute would have, that would be true, because under the interest statute, you have to have the same taxpayer making the overpayment and the underpayment. And I think there's a big difference between the time that's relevant for the overpayment and underpayment. As I mentioned before, you don't look to when you settle up. That's when you pay the overpayment, you pay the underpayment, or you get a refund of the overpayment. What we're looking at is when they actually occur in time. And yes, you may find out that there was in fact an underpayment when you realize, oh, well, you deducted something you shouldn't have, but that underpayment still happened at the time you file a return that underpaid your taxes. And there's a similar definition for overpayments under section 6601 and 6661 respectively. And that's what the Federal Circuit looked to determine that they were the same taxpayer. And with regard, I think the bank sort of has an overriding argument that this is somehow unfair because of this, offsetting the liabilities, which was done under section 65, under Revenue Ruling 6520, that the interest should also be offset. But Congress intentionally chose these differential interest rates, and it did so because it was concerned about corporations sort of gaming the system with interest and with other tax attributes. And then it also, at the same time when it enacted this netting provision, it was looking at, concerned about the situation where the same taxpayer, one individual taxpayer, had had basically a net amount owed of zero because the overlap, because under the existing law, the Eighth Circuit had said, if you have an overpayment and you get your refund, and then you discover you have an underpayment for the same year later, they overlapped, you can't, well, I guess 2 separate years, because they did say they could have annual netting. But if you had these two payments by the same taxpayer and some period where you had a net tax owed of zero, you would still owe interest. And 6621D was trying to get at that situation.
The statute, to say what you say, and maybe you're correct, to say the same tax by the same taxpayer for the tax year in which the overpayment or underpayment was due. I mean, that would settle the timing question if it had that phrase in there, but it's not in this statute.
Well, I think if you look, it uses terms that are defined in the Internal Revenue Code. The statute uses these terms overpayment and underpayment. And if you look at 6601, it explains that when you reach the point where the tax is due and you've underpaid, that's when the underpayment is created. And similarly with the overpayment, when you reach a point where after the tax is due and you've overpaid. So these are terms that are defined by statute. And so it's not, Congress didn't need to put it in 6601 or 6621D itself, because what an overpayment is and what an underpayment is and when they happen are defined in these other statutes and the regulations under them that we cite in our brief. And I think when you look at what Congress, if Congress wanted to follow the liability statute, all it would have had to do is say, if they're the same taxpayer when the underpayment, the liability on the underpayment is paid, or when the overpayment is refunded. And that's not what Congress did. Instead, it tied it to when the overpayment and the underpayment actually happened.
What is the impact of our case in Air Power insofar as the use of state law here?
I'm sorry, which case, Your Honor?
Air Power.
I'm sorry, I'm not remembering the specific facts of those cases, but I think, under Delaware law.
It was a case that went to whether we look at the federal taxing law, whether we're looking at the express language and whether it's necessary for an implication of that it should be dependent upon state law.
Well, I think, first of all, in none of the legislative history or anything looks to merged entities. So I think within the, the history or the statutory language in Section 6621 itself, there's nothing that suggests that state law should be
So
what.
is Section 6621 dependent upon state law to any degree?
Well, I think when you look at a phrase under federal law, the Morgan Supreme Court case, and cases like the Dry and Irvine cases that we talk in our brief are all Supreme Court cases that say when you're looking at what a term means under for purposes of federal tax statute, that's a question for federal law. So when you're looking for what does same taxpayer mean, that's a question for federal law. And I think there are a lot of things about federal tax law that make it not make sense to treat the same taxpayer question as allowing merged entities when they still have no connection at all, but just later merge, to be the same taxpayer. And I think, first of all, in Section 381, where the code talks about what happens as the tax consequences of a merger, it talks about what attributes transfer from one entity to another, from one taxpayer to another, which assumes that the entities are
381's
separate
not
taxpayers.
exclusive. I mean, there are a number of cases that are out there that says this gives you a list of things that go in a merger, but that's not all the things.
But I think the point is that it uses the language about one thing being transferred to another. And here, the statutory language we're dealing with is language that asks them to be, that says they have to be the same taxpayer. And so it doesn't fit to say it's okay if, they're as if they're another or things are transferred to another. What you need is for them to be the same taxpayer under the words of the statute. And I think to treat it as though these pre-merger entities are entirely separate, can retroactively be the same, poses a lot of problems for federal tax law, because federal tax law uses an annual accounting, and each taxpayer has a separate taxpayer identification number. And for the years pre-merger, each of these taxpayers was, for tax purposes, an entirely separate entity with a separate tax accounting. And the code doesn't, if they were retroactively the same, you would assume that at least for open tax years, you would go back and amend returns so that all the attributes would go backwards, but that's not what happens. Instead, they keep their same returns, and only in the year of the merger, the acquired corporation does a short year return, and then only thereafter are they filing one return together as one entity. I think another thing that would create real issues about having these same taxpayer, having taxpayers treated as retroactively the same after a merger is the fact that under some state laws, including Delaware law, you can have different types of entities that are treated differently for tax purposes merging. So you could have a situation where you had something that was taxed as a partnership merging with something that's taxed as a corporation. And then to go back and say that for tax purposes they're retroactively the same taxpayer would create a huge mess. And so I think that's another reason why the tax code doesn't contemplate the retroactive application that the bank would urge here. And I think when you look at the Delaware law itself, it doesn't support, if you do get to Delaware law and find it relevant, I think that really, as I mentioned before, all the things that the bank cites talk about the entities becoming the same post-merger. And if Wells Fargo and Energy East are correct, and I think they are, that you look to this one point in time for the overpayment and the underpayment, there's nothing in the Delaware law that suggests that they're retroactively the same taxpayer. I mean, the Delaware law talks in terms of, uses a future perfect tense in terms of talking about once the merger happens, what will happen in terms of there being prospectively the same. The merger agreement here, likewise, talked about what will happen going forward and what happens after the merger takes place. And I think the case law talks about it being as if, things transferring from one to the other repeatedly. And that certainly suggests that they're not the same taxpayer. So fundamentally, we have a situation where, the actual statutory language is what's at issue, and this language about overpayments and underpayments by the same taxpayer, I think the Federal Circuit correctly concluded pertains to a particular period in time, and there's no reason to conclude that these retroactive, that somehow retroactively these entities that were undisputedly, I mean, it's the same taxpayer. In fact, the bank repeatedly says in its brief that these were pre-merger overpayments and overpayments. There's no question that at the time that an underpayment came into existence and the overpayment came into existence, they were the same taxpayer. Does that answer your question about the retroactivity, Your Honor?
I understand your answer.
Okay, all right, thank you. Are there no further questions? We just ask this court to follow the
Can I
federal
just
circuit.
ask one?
Yes.
I think I understand your position on this, but just to clarify, if after the merger is when everything, all the underpayments and overpayments are sorted out, right? And they figure out who owes and what interest and
I mean,
such.
in this case, they did find, some of them actually did span to after the
Yeah.
merger. So it's possible that you could have had pre-merger overpayments and underpayments that were resolved before, and I think, but I think in this case, at least some of them extended past the merger date.
But if Merrill had, if we find out after the merger that Merrill had, across different tax years before the merger, had an overpayment and an underpayment that both were accruing interest at the same time, Merrill could still take advantage of that, or Bank of America now could take advantage of that post-merger because would be an overpayment, underpayment by the same taxpayer.
Well, so you're
right?
saying
'Cause
that
Merrill pre-merger,
Merrill's pre-merger,
across different tax years, it had an overpayment and underpayment. Interest was accruing at the same time on both.
and when was the bank's,
And then the merger happens, and
and then after that, the bank has an overpayment?
no,
Or an
no, no.
underpayment.
Merrill had them both pre-merger.
So it was both Merrill, they both belonged to
Yes,
Merrill
but they
pre-merger.
didn't figure it out until after the merger, and then they're trying to sort it out.
So Merrill has both the other payment and the
Right.
underpayment pre-merger in this situation.
Right.
So yes, that would be the same taxpayer.
It doesn't lose its ability to take advantage of interest netting just because it merged into another entity, is what I'm asking.
That's correct, and I think that really, that would be a situation where it would still be the same taxpayer that had the overpayment, and it would not make any difference.
Thanks.
So if there are no further questions beyond that, I would just ask that this court affirm, consistent with the Federal Circuit's opinion, which reached the same result on the exact same facts. Thank you.
All right, thank you. Ms. Saharsky, you've got some rebuttal time.
I'd like to start with Judge Rushing's question, the last question. In those circumstances, there can be interest netting, but there's no Merrill Lynch anymore. Merrill Lynch is gone. That taxpayer is gone. There's only one taxpayer. It's Bank of America. It's the only taxpayer left standing, and it's responsible for everything going back, even things that were termed Merrill Lynch overpayments and underpayments in the past.
Like at the time that the interest was accruing, back then, it was Merrill, right? Merrill
Right, but
was owing.
Merrill is
and-
gone, so if they want to try to get money from or do any kind of tax consequence from Merrill, Merrill's gone. The only thing left is Bank of America. That's kind of our fundamental point. We're figuring out, as our colloquy before was about, we're figuring out now what to do with the overpayments and underpayments and the interest. There is only one taxpayer left, and it is responsible. It is the same taxpayer for all those other purposes. And let me say, this is a narrow rule that applies only to merger. We're not saying any time that there's like a company that buys another company, but there's a separate corporate existence or whatever else, they can try to take advantage of this interest netting. It is the consequence of a merger that you are the same forwards and backwards and for everything. It's just this narrow carve-out that they want for interest netting. Now, I know there's been a lot of discussion today, so I just want to step back and say there is a very straightforward path through this case.
Is that an incentive to merge? Would this be an incentive to merge if you knew that you had these underpayments and overpayments in a situation? Is that a basis for doing this?
No, and let me give you 4 reasons why. 1, this is entirely hypothetical. Like, the government has never come up with any situation in which someone has considered possible interest netting as a reason to merge. 2, mergers happen for business reasons as opposed to tax reasons, but for valid business reasons. And here, there was a really important business reason.
I was
Merrill
saying
Lynch.
about the amount of money that's on the line here that you're dealing with here. What about this? I think it was Bank of America that had the underpayment here. What would the situation be if that was already in litigation when they merged?
So the tax
Would
years.
that change the scenario any, if the fact that the government pursued it and brought litigation to get that underpayment before the merger?
The tax years would have to be open, and the government would have, or the Bank of America or the taxpayer would have to make a claim for it. And so in these circumstances, the tax years were open because of all the adjustments that the government was making until 2014. They finally determined the overpayments and the underpayments. It was time to figure out the interest netting. They didn't agree with us. We made a claim, and then eventually that went to litigation. And so the merger happened while the tax years were open, before the audit concluded, and that's our position.
So yours is dependent quite a bit on the events that occurred after 2005, the openness of the tax year, the fact that they asked them for review and whatever. But does all of this, in terms of the overpayment and underpayment, do they arise from the events of 2005?
No, because the government made the adjustments in 2014, and those adjustments are not just because of facts that happened in 2005, but can be because of things after the fact, like lost carryovers or carrybacks that are on multiple years, like foreign tax credits that are on multiple years, like retroactive application of new government regulations. So it's not just like they're facts in 2005 and they weren't determined the right way in 2005. It's that a whole bunch of stuff was happening up through 2014. And so this idea that the government says that it's fixed in 2005 just isn't right. But I do want to get back to the other question.
But on that point there, if you're saying it's not just 2005, does any of those changes affect another tax year?
Yes, I think there were changes that affected other tax years, and to be fair, I think it's everyone's.
But the ones we're talking about here, do they affect, it seems to me, you can have all those changes where you got different things that are happening, but are they going back to the events that occurred in 2005?
I think some are events that happened in 2005, and some are adjustments that are things that happened after 2005. And to respond to your question, I think everyone is relying on things that happened after 2005, including the government. And they're not deeming the overpayments and underpayments to have occurred in 2005. They say, for example, for test case 1, the overpayments occurred in 2008. They say that's when the overpayment arose. And so to get back to your question about...
Make sure I'm just trying to understand. So 2005, is it the fact of the underpayment or the overpayment, is that the basis that drives what occurs after it? In other words, you have to have a foundational basis to start with. If they had done it correctly in 2005, would those things that occur after 2005 have made a difference? I mean, or would you have any basis for anything if it was correct in 2005?
Well, I think things happened after 2005. We filed the 2005, the Bank of America and Merrill Lynch 2005 tax returns stated zero balance. And it was events after that that both the government and...
if those had been correct in terms of saying zero, would there be anything that could, I mean, does it have any input if you don't look back at 2005?
Well, if you were only looking at 2005, I think we wouldn't owe any money because of the zero balance in the returns. But I understand your question, and my point is, whether it's for this test case...
My question is dealing with what is the basis? When you're starting with something in the beginning, what are you looking at? What are you using it to measure it against? And so you're saying that these events that occurred is showing you did something wrong, but it looks like to me it keeps going back in 2005.
Okay, so we're figuring out the Merrill Lynch and Bank of America 2005 tax years. That is the objective. But those tax years are determined based on the adjustments that were made were based on future events, including, and they're not just that all the facts were known at the time, there can be retroactive applications of regulations, there can be lost carrybacks that apply to prior years, et cetera. And so it's just not the case that it was only the facts in 2005. And the government doesn't say that the overpayment and underpayment dates are in 2005 or even 2006. It says that the overpayment dates are in 2008. So I guess the kind of broader answer to your question is, no one is really fixing this all in 2005. The government has to consider all these events in the future too in order to try to get the money from us, but they just don't want to consider the effect of the merger. Can I just wrap up? I see my red lights. Okay.
Quickly.
So I think there's a straightforward path through this case. The statute just doesn't have a timing element. It just doesn't answer that question. And so, we're the same taxpayer now. We're settling up. And the last thing I'd ask the court to look at is the undisputed purpose of this statute. If you don't owe tax, you don't have to pay interest. The government agrees that we can net the payments for everyone. And in situations where we don't owe tax, they want us to pay interest, and they have no explanation for that, none at all. We urge you to reverse.
All right, thank you very much. We appreciate the argument of both counsel, and we'll come down and greet counsel, but first I'd ask the clerk to adjourn court for the day.
The honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.